Miss Kelly McMahon, Irish First Mothers Group, and Mr. Finton Dunn, Irish First Mothers Group. You're very welcome. Thank you for being here. So I think it's Kelly's presentation.
Thank you. Mr. Chairman, Deputies and Senators, thank you very much on behalf of Irish First Mothers. We appreciate the work afforded to the heads of the bill thus far, and thank you for the opportunity to address you here today. My name is Cathy McMahon. I'm the founder of Irish First Mothers, and I am a First Mother.
Okay. If you want to pause, and we can. You're all right, take your time. It's a very important day, and it's a very sensitive day, and your bravery is to be American. Well done. And thank you for being here.
My first child was born in April 1974, after I spent 4 months in the Good Shepherd Convent in Dunboyne in County Meath. I was aged 18. I nursed my child for 7 days, but on the day of my discharge from Holles Street Hospital, a nurse took my infant daughter without warning. I was later forced to sanction her adoption. I did not see my daughter for another 28 years. We reconnected through the Adoption Persons Association database. She'd registered and I had registered, so we reconnected that way. I hadn't planned on putting that in, so I'm just adding it in because I think it's important. I have experience of connecting with my child through a registry. I'd previously worked in my community where I raised my subsequent 3 children. And so in early 2014, I founded Irish First Mothers. I'd been a member of the Adoption Rights Alliance for on and off for a while, and I realised there seemed to be a need for a place where mothers could come together and talk and share their experiences and help each other to overcome some of the damage that was done. So Irish First Mothers is a peer-to-peer mutual support group for women who lost children to adoption. We have over 50 verified members, and we range in age from early 40s to mid-70s. Most of us were incarcerated in so-called mother and baby homes, and I'm representing our majority view. Discussions about this heads of bill often refer to the so-called privacy rights around access to adoption information, but commentators often confuse privacy in respect to information with privacy in regard to personal contact. Any citizen is entitled to live in privacy, but there are already well-crafted laws to defend against unwanted intrusion on one's personal privacy. So sections of the heads of bill which use a contact veto to limit privacy intrusion are arguably redundant. Such privacy rights were not what the Supreme Court had in mind in the often quoted IoT versus B case. That hinged on confidentiality. Whether the natural mother had been given specific guarantees of confidentiality about her participation in an adoption. Well, I'm here to advise this committee that we mothers never sought, nor were we ever offered confidentiality. Instead, we were threatened to never attempt to make contact with our children again.
Take your time. You're doing well. Try to get a glass of water. Take a drink.
Thank you, Chairman. I have some. My own abiding memory of my incarceration in a mother and baby home was of the mothers screaming in anguish following the often forced removal of their babies. Our rights and welfare were not paramount concern to those around us, and none of our First Mothers group were offered confidentiality. The court relied on the existence of women who got special confidentiality assurances That cohort of women simply does not exist. The other broader confidentiality argument is that the natural mother or other parties had a general right to expect confidentiality in adoption proceedings. Perhaps so, if Ireland's historical adoption practices were mostly legal. But the bulk of historical adoptions were the result of sustained coercion. Women coerced into convents, coerced during pregnancy and birth, kept as mere dependent chattels, finally to be coerced into signing adoption consent forms which violated our parental rights and interfered with our infants' natural bonds. These unsound consents constituted a systemic fraud upon the adoption court and rendered Ireland's historical adoption procedures substantially illegal and a violation of constitutional and international human rights. So those birth and adoption information records are not normal confidential records. They are our evidence related to the illegal acts to which we and our infants were subjected. But first mothers and injured adopted persons who likely never will see related prosecutions over these illegal adoptions. So the very minimum we can offer all potential victims of this illegal process is prompt and unhindered access to the evidence, the records of the crime against their natural identity. We feel that all parties to illegal historical adoptions, the child, the natural parents, the adoptive parents, have rights to available information in relation to the adoptions. All of the mothers in our group who expressed an opinion are opposed to vetoes. Our excessive delays in adult adopted persons getting their birth information. We also estimate that around 98% of first mothers are open to reconnection with their adopted children at some level, keeping in mind that access to information does not mean automatic contact. The committee might also benefit from the recent experience of the state of Victoria in Australia, which earlier this year passed an adoption amendment bill 2015, thus removing all references to contact preferences from their adoption laws in 2013. The removal did not affect a person's option to register their contact wishes on Victoria's Adoption Information Register. Supporting the recent bill, 2015 bill, the Victoria MP Sam Hibbings wrote, "Contact statements set up yet another barrier to contact between natural parents and adopted children being re-established. It is not appropriate when we are dealing with two adults who want to regulate contact with each other. We should revert to the framework we had in place for 29 years where Victorian adults regulated contact between each other. So for 29 years, in Victoria, in Australia, adult adopted people and their natural parents, and indeed adoptive parents, have been able to get access to information once the adopted person reaches the age of 18. Yeah. I just want to finish up. I have submitted a longer document, but I was shunned, labelled and incarcerated because I was a so-called single mother. No one cared the impact that this would have on me or how labels and stigma and my treatment would affect my entire life. As a natural first mother, it was not as a result of my inability to parent or raise a child with love that our children were taken from us. So while it's true that adoptive parents can provide a loving home, so also can a single parent. I went on to have 3 more children. Sadly, my third child died in a road accident aged 16, but my surviving marital children are upstanding members of society. The first mothers I know are caring, sensitive and capable, and they deserve to have their parental rights defended. I'll leave it at that,
Thank you very much indeed.
and I'll talk to you later, Gillian.
Thank you very much indeed. And can I just say to you and to Mary that you have done the state today a great service by your testimony and your advocacy and your presence. I can thank you both for your presence today. Thank you. And in fact, the people in the earlier presentation this morning, I can safely say that as chairman of the committee, it's probably one of the most moving mornings we've had in our committee, and we've dealt with a lot of contentious issues. It's been a very moving morning, this one and the previous session. So can I just thank you all for your presentation, and I want to thank you for that. So we'll hand now back to the